Good morning. Welcome to Senate Election Law Municipal Affairs. For the hearing on Senate Bill 110, recognize the prime sponsor, Senator Fenton. Welcome.
Well, thank you for having me. Thank you, Mr. Chair and lady and gentlemen of the committee. I am Senator Donovan Fenton for the record. I represent Senate District 10, which is most of Cheshire County and Peterborough. It's a lot of towns to list, so I'm not going to list them. I'm here to introduce Senate Bill 110, relative to the administration of emergency shelter program by cities and towns. This bill is a recommendation by my municipality to update RSA 126 dealing with emergency shelter programs and residency. The New Hampshire Welfare Administration approved a policy to help guide welfare administrators in New Hampshire in regard to residency and temporary housing. We're seeing a lot of homelessness in New Hampshire, and often people seeking assistance will come to a larger town because the smaller town might not be open or doesn't have staff or an office. These larger towns will provide assistance or aid, but the smaller towns aren't necessarily reimbursing them. So we want municipalities to communicate and coordinate assistance options with each other, including reimbursements from municipalities of origin. There's also an amendment, it should be at your desk. You're going to see that fixes some issues with the residency. And I'm happy to take any questions, but I would say ask the experts behind me. Thank you.
Thank you. Questions of Senator Fenton?
This one should be easy, but I do have an amendment here from you. Did you want to talk about that?
That's the amendment, yeah.
Okay.
It should be 0251.
Yes.
Yeah, so that fixes kind of the issues with residency and where they domicile so that they can still vote. Yeah, it's best to sum it up.
Seeing no further questions, thank you, Senator Fenton.
Thank you all.
Chair recognizes Ms. Natalie Darcy from the City of Keene. If Ms. Darcy is here? Oh, thank you.
I'm Natalie Darcy, Human Services Manager for the City of Keene Human Services Department, and I wanted to speak in support of 110 relative to administration of the emergency shelter program by cities and towns. I can't tell you how delighted I am as a welfare administrator to see in part the ethics resolution adopted by the New Hampshire Local Welfare Administrators Association incorporated into this bill. People experiencing homelessness often seek or are referred to Keene from around our region. As a community, Keene can take pride in that we are supportive of humanitarian initiatives. This approved resolution supports these humanitarian efforts while acknowledging responsibilities for municipalities of origin. Currently, under the law, a person can come and stay one night in a city or town and be considered a resident of that town because he did or she did spend that night. Keene is a hub for support and emergency services in a rural area of the state, as are other cities throughout New Hampshire. Passage of this bill would clarify and increase municipality fairness and not place undue burden on just the cities while increasing the tax burden. I see the resolution added to this bill as the approval of improved best practices that fosters fairness and consistency between municipalities. Currently, individuals having residency in shelters, motels, treatment centers, and hospitals are discharged or exited for services and told to go see the city in which the services are located and are told to ask for motel vouchers. This bill would help facilitate billing the municipality of origin for services provided by the host municipality. Regardless, Keene and local welfare offices throughout the state continue to be accessible and accountable to the people in need and to taxpayers that pay and meet the need. Thank you.
Questions of Ms. Darcy? Seeing none, thank you very much for your testimony.
Thank you.
Chair recognizes Ms. Elizabeth Dragon from the City of Keene.
Morning. My name is Elizabeth Dragon, and I am the city manager of Keene. I've been there for the past 5 years, but my career spans 25 years in New Hampshire, and my experience serving the homeless population has been very different depending upon the community. 2 of the 4 communities I've worked in have homeless shelters. Both of those communities also serve as a regional hub with shopping plazas, hospitals, and major employers. Keene is one of those 2. I strongly believe every community in the state of New Hampshire has a role to play in regards to responding to homelessness, but I don't see that happening. There's not enough financial motivation to bring everyone to the table. In the 2 communities that I served in where there were no shelters, if a homeless individual came in for assistance, to meet the need, we would search for an open shelter bed somewhere in the state of New Hampshire and then pay to transport them there. In communities with shelters like Keene, we see homeless individuals from across the state and beyond. In Keene, our per capita homeless population far exceeds the state average of 12.3 per 10,000 of population. Between the city and our shelters, we are 5 times that. And I think you would hear from other communities with shelters that they are experiencing the same thing. In addition, small towns often have very limited welfare hours, and people seeking help will go where they can get it. And oftentimes in Keene, in our region, it's Keene. And Keene fulfills their legal and ethical obligation to serve anyone, regardless of residency. And this bill does not change that. But what it does do is make clear that an individual showing up on our doorstep, whether by their own means or being dropped off by another town, which I have witnessed, is still the resident of the town they come from, even if we temporarily assist them using a shelter or a hotel. They do not gain or lose residency while in emergency housing, hospital, treatment centers, etc. It keeps the community of origin on the hook, at least financially, for the assistance provided to the residents. The City of Keene's use of hotels has dramatically increased. In 2019, we only used the hotels for 1 individual and 1 family. In 2022, we have housed 51 individuals and 20 families using hotels. In addition, Southwestern Community Services, who provide shelter space in Keene, has also placed at least that many individuals in hotels. This is a growing problem. COVID and the housing shortage has amplified the problems related to our welfare system and put a great deal of strain on the handful of cities and towns who are providing shelters and supportive services. The state's own strategic plan related to homelessness acknowledges the uneven and inconsistent response across all towns, and as a result, the participating communities are shouldering a disproportionate amount of financial responsibility. We work hard in our region to engage our partners to be part of the solution, but that has to include financial responsibility. This bill by no means solves all the issues related to our welfare structure, but it is a step in the right direction, and I ask that you support the passage of this bill. Thank you.
Questions from the committee? I have a question.
Yes.
If you were here before the hearing started, I did
Yes,
speak to a
yes.
couple people about residency.
Yeah.
And certainly, because of the conflict between residency, domicile, for other purposes, including motor vehicles, elections, etc., I have concern that this doesn't say residency for the purpose of this chapter, but I guess I would rather see it say reimbursement for expenses for emergency shelters for individuals will be determined by whatever.
Yeah.
Okay, and not even use the word residency in there. Comment on that?
Yeah, thank you for asking. I did hear that is a concern, and I understand that because residency is defined in statute in another location. I do think we can come up with some language to work around that.
Alrighty. I can't speak for the committee, but I would tend to give you a couple of weeks to do that, and other people Seeing no other questions, thank you very much.
Thank you.
Todd Marsh. Full disclosure, Todd works for the city of Rochester, and I am the city councilman in Rochester also. I don't know if there's anything else I should tell him, Todd. I guess I should turn my
Maybe we should just
microphone
keep it at
on.
that.
All right.
Thank you, Senator Gray. Members of the committee, I'm honored to be here today for this opportunity. So I'll refer to my notes for my sake and more for your sake here. So yes, my name is Todd Marsh. I am here representing the New Hampshire Local Welfare Administrators Association. I am their president. I am also the welfare director of the city of Rochester. Prior to my employment with Rochester, I was the director of the Homeless Center for Stratford County in Rochester, the first director, and residential manager of the My Friends Play shelter in Dover. I have held multiple elected positions within my hometown city of Somersworth. I share this with you not because I am seeking employment or running for any other office, but to demonstrate my broad knowledge and varying perspectives of what I will be sharing with you today. The New Hampshire Local Welfare Administrators Association is a professional nonprofit organization that educates and supports our municipal members to foster compliant, humanitarian, and fiscally responsible assistance practices when assisting residents with New Hampshire RSA 165:1, statutory obligated basic needs. Municipal local welfare is a resource that is often down the street from where people live, in a place where people are not treated like numbers, but community members who happen to be in need. Not only that, we are increasingly becoming a valuable expert, social service voice, and resource to decision makers within our town and city halls throughout New Hampshire. We are often a bridge of communication and understanding between outside agencies and municipal leaders. We are increasingly at the table of discourse for discussing humanitarian issues, including homelessness and housing. We are proud of our efforts during our moment in history, including the pandemic, including collaborating with other agencies and other organizations within New Hampshire. The Emergency Rental Assistance Program, ERAP, was instrumental in providing housing for people affected by COVID-19 and transition to assist those who are not. As you are aware, hotels and motels paid for by agencies and organizations have been used for emergency housing purposes when needed for many years. However, as our country's multifaceted challenges increased, so has our use of hotels and motels. As our multifaceted challenges increased, so has our use of traditional shelters. As our multifaceted challenges increased, so has the use and development of seasonal overnight warming centers. As our multifaceted challenges increased, so has the use and development of substance disorder treatment centers. And as our multifaceted challenges increased, we have learned a multi-pronged approach is needed to solution find. In June of 2022, after months of solution finding discussions, including mitigating any unintended consequences and in informing NHMA and legal aid attorneys of our intentions, the New Hampshire Local Welfare Administrators Association, by unanimous vote, including many small towns, adopted our ethics resolution agreement. It was to provide, and I'm quoting from our resolution, increased collaboration and consistent liability expectations, further establish general assistance best practices, and foster increased municipal support for temporary emergency assistance by clarifying municipal liability due to temporary emergency housing placements. Although our association did not initiate SB 110, we are flattered. Much of our thought and best practice language has been used. Passage will establish a common ground, fair and equitable agreement on residency in relation to hospitals, treatment programs, and emergency temporary housing services and placements outside of a municipality of origin. Passage will foster increased municipal support for temporary emergency housing and other supportive services by clarifying residency liability to the municipality of origin. Clarification of residency for local welfare purposes will increase municipal liability fairness while continuing to comply with humanitarian obligations indicated in RSA 165:1. The clarifying humanitarian safeguard language in this bill indicates assistance needs to be provided to meet basic needs of transient individuals or residents of the municipalities. Also, and I'm quoting, municipalities shall, in our resolution it should, in this bill it's shall, communicate and coordinate assistance options with each other, including reimbursements from municipalities of origin, RSA 165:20A, when it is determined unreasonable for the person to physically return to the municipality of origin due to transportation, timing of need for assistance, or residency is unclear. That's safeguard language to protect the person. If timing is an issue, if the nature of the emergency is an issue, then they need to be seen by someone, and it may very well be where they're at until coordination could be worked out from the place of origin. That's very important. As you're aware, initiatives to increase emergency housing throughout our state are often met with concern for increased financial liability for host municipalities. The clarification continues to honor municipal legal and humanitarian obligations, increases municipal collaboration efforts, increases provider services, and decreases concerns for financial liability to the host municipality. This is a bipartisan common ground improvement to the benefits of local welfare. The voice of social services within our town and city halls. You may hear some pause expressed from our advocate friends, and we have many, and I respect them for it. They may speak of potential unintended consequences, and I would expect them to ask you to think it through. However, our association has done that, and the sponsors have done that. I am confident our included humanitarian safeguard language will protect those we are obligated to assist while improving our overall network of assistance opportunities. In conclusion, it is important to be aware that most of our municipalities play nice in the local welfare sandbox, including the greater Seacoast area, which our ethics agreement is modeled on. However, there are pockets throughout our state, too many, for various reasons, that will benefit from this narrowly targeted clarification and improvement in the law. I will further say that to answer Senator Gray, and this will not be an ideal answer for you, however, our language, it does include language that indicates throughout the spill that it is for local welfare purposes, right? And we were intentional with that because we were aware, we wanted to be careful that we weren't making this overly broad, right? It does indicate in multiple areas for local welfare purposes. And I think that may not be the solution, but I just want to make the committee aware that we were conscious of it, we were aware of it, and we wanted to make this narrow. We wanted to make this targeted for local welfare. And I'll leave it by saying, in part, and it's in our resolution, this is an advocacy resolution. In part, we want to increase emergency services throughout our municipalities, including shelters and warming centers and substance use centers, treatment centers. We can do that if we can minimize the financial liability that is occurring. Because there is a thought behind closed doors, perhaps. Again, we're local welfare. We're in some meetings. There is a thought behind closed doors. If you build it, I know what you're all thinking, they will come. And they are human beings, and they matter. But I think we need to meet our decision makers, we need to meet our city managers and town administrators where they're at, and be sensitive to that while meeting our RSA 165 legal obligations. I can continue, but I will stop there.
Questions from the committee? Seeing none, thank you very much. Oh, yep. Senator.
Sorry, Chair, I
Spoken.
was a little slow with my hand there. So thank you for your testimony, and I think just to build on sort of the line of question the Chair was raising before, you know, residency is obviously an important component of all this. So if I understand it, the residency definition used in here is from RSA 21.6A, but then is sort of modified by the proposed language of the bill.
Yes. primarily, our intent was to include motels and hotels to existing language when used for emergency housing, not leaf peeping, not, staying for a weekend. When used for emergency housing, and specifically when paid for, and it's in the bill,
Yep.
when paid for by agencies, by organizations, if as written, if a family self-pays into a motel because of their situation, as written, that's not paid for by an organization or an agency. And so they would be a resident of the community they move to for local welfare purposes. If it is paid for by an agency or organization, they would be a resident for local welfare purposes, as it's indicated in the bill, of the town of origin, until they self-pay for 30 days, and then they become a resident for local welfare purposes of the new municipality. We use 30 days. Yeah, I'll use the word, it's used every once in a while, occasionally, compromise. We use that word as a compromise, and we thought that was fair. The 30 days. And also, we use 30 days because it's not unusual. I'm getting into the weeds a little bit, so forgive me, but it's not unusual for an agency, let's use city local welfare, okay? For a town, I want to be careful of the town A and town B because I could get confused, but I'll do it anyway. It's not unusual for town A to assist someone in town B because town A doesn't have a motel, right? And that town A may expect that family, if they have an income, pays something towards their motel, reasonably. So that family may pay a week or two in a motel, but they can't afford more than that. That's why we use 30 days, right? Because we're aware that it can kind of go back and forth a little bit between an agency and the person in need. And there are some who felt that 30 days was not long enough. But we thought that was reasonable.
Are there any other questions?
Can I follow up if I may?
Senator
answer?
Perkins?
Just because you're here and because you're the president of this administration. So basically, the proposition is to, have this communication and coordination between municipalities be pursuant to RSA 16520A, which essentially is a mediation. I mean, it looks like, a panel of municipal officials meet and decide on what the reimbursement should be on a case-by-case basis, or?
No, I appreciate that question. Well, in local welfare, virtually everything's on a case-by-case basis, according to the law, right? Because situations differ, which is one of the reasons I like working in local welfare, right? It's not categorical assistance. It depends on the situation, and we can be flexible. But currently, yes, it does indicate that Town A could seek reimbursement, or excuse me, Town B could seek reimbursement from Town A if that family or individual cannot reasonably get back to Town A because of timing, because of transportation. And so that welfare official from Town B, where the motel is, can seek reimbursement if they end up assisting into that motel, Town A. And it will be done, as it indicates in the law, through communication and collaboration. And I will say this, we're not void of that now, but it's not happening enough. And that's the reason for the law. And I think it's important to point out that word shall. There's nothing in RSA 165, there's nothing in other laws stating that we need to collaborate and coordinate, communicate. We do it because it's best practice. But if a town refuses to, right, it doesn't answer their phone because they feel like it's their best practice, it saves money, then they might, and that's what's happening in too many cases.
Additional questions from the committee?
No, sir.
All right, thank you very much.
Great,
Thank
thank
you.
you. I appreciate it.
Tower?
Good morning, Mr. Chairman, members of the committee. I'm Steve Tower. I am the new managing attorney of New Hampshire Legal Assistance's Manchester office. I'm also one of the co-directors of our local welfare project. As a little bit of background, what our local welfare project is one of our attorneys every day is scheduled to be on call for when a person is having an issue with a town allegedly not meeting their statutory obligations under RSA 165 to provide assistance under the local welfare law. Because generally, a lot of these local welfare cases are emergencies. Somebody is about to be homeless or about to have their utilities shut off, or they are currently homeless. We decide that we need to structure our whole program around having somebody available every day to be able to jump in and reach out to the town to try to resolve things. And if in the rare instance where we're not able to resolve things directly with the town, we sometimes get involved in litigation. But generally, by and large, we're able to either resolve things with the town or identify that the town isn't doing anything wrong. This bill is interesting because it does address what we recognize as a very serious issue for the sort of hub towns, the towns that have more resources, you know, Keene, Manchester, Rochester, Conway, where they have maybe shelters or medical facilities or local Department of Health and Human Services offices that their surrounding communities do not. So people who tend to end up in a situation where they're experiencing homelessness or about to experience homelessness, or are trying to survive in that tight situation, they end up in these hub towns. And that it has been a constant issue that sometimes these towns feel like they are disproportionately bearing the burden of the homelessness crisis compared to their neighboring communities where many people have come from and end up now in their town. And we're very sympathetic to this issue that the bigger towns, the hub towns experience. And we generally work pretty closely with a lot of these towns. The larger municipalities tend to be connected with the Local Welfare Administrators Association, which from our perspective is a great thing. The association is fantastic. We almost never have any disagreements with them about how local welfare should be handled in the state of New Hampshire. So those towns that are involved with the association are generally really good from our perspective. But not every town in the state is really involved with the association, and some of the smaller towns who may not have a full-time local welfare officer or may only get a couple welfare cases coming into their door in a year might not be fulfilling their obligation under the statute correctly. So as I talk about this, I'm going to use hypothetical as an example, Keene and Walpole.
If you'd stay on the bill really talks about how the reimbursement is going to happen, that there's no allegation that I see in the bill that it's not being provided, or if it isn't being provided, that it would be, litigated under some other statute. But
So
I'm trying to move us along.
fair point. So my issue with the bill is the residency definition issue. We don't really have an issue with that. Our biggest issue is with Section V5, where it talks about municipalities shall coordinate and communicate with each other when it is determined that a person is unable to physically return to the municipality of origin due to transportation, timing, or residency is unclear. When the Welfare Association put forward its resolution that this bill is sort of modeled on, we raised our concern with the Welfare Administrators Association that who is making that determination that the homeless person is unable to return to the municipality of origin? Because that determination, it seems, would be made by the town, where the person walks into the door and says, I need help. And then the town says, well, I think you can get to the town that you came from and apply there, so you should do that. And the person who is seeking assistance might feel otherwise. They might feel that that's not possible. as the law is currently written and has been decided by the Supreme Court for 150 years, a person is able to apply in the town that they are currently present, whether or not they are a resident. And my concern was that this language here about the person being unable to physically return to the other town conflicts with the existing law under RSA 165. And when it was just a non-binding resolution between the local welfare associations, you know, the backstop was, well, the existing law says that they can apply. You know, maybe the towns would like to refer people, but if the person insists that no, I actually can't get back to that other town that I came from, I don't have a car, or I have nowhere to go tonight, and the office closes in 3 hours, and it's 2 hours away. Had said that in those instances, the law is the law, and the resolution takes a backseat to what the existing law is. Well, this now changes what the law is,
But again, what it changes is who pays, okay? So again, I'm looking at this, and I'm looking at it, from the point of view that, the point of this whole bill is, does entity A or entity B pay, okay? If you've got further testimony on that, I'd be glad to hear it. Other than that, I'm going to sign a go-do to Natch, because he represents the NHMA represents the big communities and the small communities, and I'm going to try to get this bill revised, and you can be part of that by contacting him.
I feel like maybe I'm not making my concerns clear. My concerns are specifically not about that. The issue about who pays comes into effect when if a town can say, you have to go back to the other town, that affects who pays, and that's part of this bill here. I think if this last sentence of 5 were dropped, the issue of determining who pays that as it exists in this bill is fine, but that last sentence, I think, shifts things.
So noted. Natch, you heard that. He'd like that dropped.
Thank you, Your Honor.
Any other questions? All right. If there's no other questions, I'm going to hold off on executing this thing for 2 weeks. Natch, like I said, NHMA represents the big places and the small places. I want to make sure that we provide the services that are needed for the people, and I want to have some kind of way to determine who pays. And if that's, an arbiter, if that's going to the court or whatever, first of all, they got to get the services, okay? That's already in statute, other places. And then I think who pays? Anybody else think that I should give them a different charge in this bill? All right.
We'll work that out, Senator.
Thank you very much. Seeing no other, we'll close the public hearing, and as soon as we're ready, we'll open the next one.
Just a lonely guy. I don't think I sent it out.
Okay. We'll open the public hearing on Senate Bill 78 and welcome the prime sponsor, Senator Ennis.
Good morning, Senators. Dan Ennis, representing District 7. My hometown is Bradford, New Hampshire. And it's my pleasure to introduce Senate Bill 78. This bill is designed to make it easier for home builders in New Hampshire to build housing. The measures outlined will stop unnecessary and often expensive bonds needed for construction. The proposed changes also provide an alternative to the often mandatory cash bonds required by municipalities for subdivision construction. There are several really smart people behind me who provide testimony on this bill and can no doubt do a better job reviewing its key points than I. So with that, I'll take any
Questions
questions.
for the senator? Seeing
right.
none, thank you very much.
Thank you.
Representative Valentine, you want to go next?
I would.
Just give them to her.
Sorry, I apologize.
That's all right.
You know, it's been one of those mornings and it's only 9:30, guys. Good morning, Senator Gray, Senators. My name is Representative Will Infantine, Hillsborough 13.
Thank you.
It's going to be really get in the weeds here. I'm going to try to make it as quick as possible here because it's kind of some boring stuff. I've been an insurance agent since I graduated from college. I specialized when I worked for an insurance company as a surety underwriter, a bond underwriter. And now that's partially what I do. I also sit in the board of directors of the Home Builders Association where I presented this bill. The point here is simply to make some changes in current law so we can reduce the cost associated with building a residential subdivision. Current law has been sitting around for a number of years. I tried to make some changes about 10 years ago, but it didn't quite work out. It wasn't a hot button. People didn't really care about the cost of what was going into a subdivision. I would like you to look at the first page with the first set of changes we've made. We have a problem right now with municipalities where they will not reduce bonds and they will not respond to home builders that want to reduce the bonds on their subdivisions. So we would ask that at least once every 365 days, once a year, or when there's substantial changes done, that they can make a request have the bond reduced. The current law states that a bond can be no more than 10% of what the estimated cost is. I have given you in your package here 2 estimates that were presented, one by the town of Derry, one by the city of Manchester. Town of Derry is adding another 28% on, and the city of Manchester another 20%. So no one's really following the rules. They kind of come up with what they want for an estimate and a contingency. So I've increased it to be fair here from 10 to 15%. But it has to include everything. You can't come up with, well, we need engineering costs. Oh, no, we need mobilization costs. Oh, we need all these other different costs associated with it. And you'll see by the 2 different bond examples I've given you, these are actual things that I'm dealing with at these local towns. One city in the state does something that I don't believe is currently legal, but I think it's something that has worked real well. What they've said is, you want to build a subdivision, that's fine. Go ahead. Start cutting trees, start clearing the road, start putting the gravel down, start paving, but you can't get a building permit. Okay? So you don't have to worry if it doesn't get finished because there's no building permits.
If you suspend for just a minute, we are reaching the limits of how many chairs I've got, and I need not to have stand ears. So just keep that in mind, or I will. All right, thank you. Sorry for the interruption.
No worries. So on the first page, line 27, we're allowing, like this one city does in the state, to allow someone to start these things. And they only have to post a bond when of the remaining amount of things to be done. So if someone does everything on the subdivision except the final coat of asphalt and some landscaping or such, it reduces the cost of the bond. Instead of it being $1 million, it could be $100,000. There are different mechanisms there. Bonds are allowed in the state of New Hampshire. And if you look at the current law, it allows you to have cash, irrevocable letter of credit, passbook, or corporate surety. There are other lines in the law, which we try to exclude here on line 22, where it says you have to do this, and it says you can't just require cash. Then later on it says, well, the town can have the type or amount of security it wants. Well, which is it? So in the town of Derry, I had to go with a client to court because they refused to accept bonds. Why not? It says we can right here. Well, no, it doesn't. Well, no, it's inconsistent with the first part of the law. So all we're trying to do is make it consistent. You can accept those 4 mechanisms, and you can't dictate one over the other. The latter part of the bill on the second page has to do a lot with time periods. And I'm not hard and fast on these time periods, but we have a situation where municipalities are not reducing bonds. I have a problem in Lebanon right now. A project's been done for a year and a half. They won't reduce the bond. I have a problem in Bedford right now where they're not reducing a bond, even though everything is done, but they have a problem with something else. Some neighbor complained about something that had nothing to do with the subdivision, but they're not going to release the bond. City of Concord, I had to call the mayor of the city of Concord because they decided that, well, we're only going to reduce bonds to 50%. I don't care if you're 99% done. We're only going to reduce it to 50%. Well, it's nowhere here in the law that allows that. When I called them on the carpet, okay, they made a change. So the bottom line is there are a lot of inconsistencies of what's going on in different municipalities. We're trying to make them more consistent. I'm not trying to take away any security from a municipality. That's why I increased the percentage from 10 to 15% for a contingent amount for a bond. And we're trying to make it easier, simpler for someone to be able to build a subdivision. Because think about it. If you build $1 million subdivision, which is maybe 25, 30 lots, to have to post $1 million in cash and then go get a loan for the bond, then go get a loan to build the road, it's just insurmountable. Anecdotally, the Home Builders Association, we think it costs $80,000 for approximately each home for all of these fees, assessments, rules, regulations that have to go forward. So nothing here to hurt anybody, to put any municipality in a lesser position. It's just to make it more consistent. So when someone says, please, I'd like to reduce my bond, you have to come out and do an inspection. Would you please do it on a timely basis? Then I have to perform to finish the road on a timely basis. Very simple changes to existing law. And I know this is kind of boring insurance stuff, but I apologize.
Senator Perkins Spilka.
Just a couple of questions, if you would. So just place me in time a little bit. So I work in renewables. You know, if we're going to build a solar project, we have to place a decommissioning bond in place with the town, and that'll sort of sit for 20 years. Is this sort of like a bond to cover the punch list once the project is substantially complete? Like, I think I just need to understand where in time
Sure.
and construction you guys are putting this.
Most municipalities, as a part of their approval process, once all the state and local approvals are in place and they want the final approval, they have to post a bond. That bond, it has to be for the amount. I give you an example,
Yep.
something like that. They have to post that to guarantee the road will be completed. They do that because they want to make sure that the people who buy a home there know that there'll be a bond to finish the paving and finish the landscaping and the curbing and all those things that need to be done in place. So they have to post that bond equal to 110 or 100 and so percentage
Of the
of that.
remaining work. Yep,
The road gets done, and then we want the bond reduced,
yep,
and then the bond stays in place. So at the end of the project, let's say they haven't put the meets and bounds in, or maybe some of the landscaping hasn't been done. The trees that you said you were going to be in your subdivision have not been built. They can say, do this, or we can call your bond.
Yeah.
When it's all said and done, finally signed off, we want them to reduce the bond on a timely basis.
Okay.
So it's always done at the beginning, and we'd like to allow, like the city of Rochester does, to say, well, just do everything you want up until the time you want a building permit. Then we bond just what needs to be done to complete that.
yeah, that makes sense. Okay, just one more if I may, Chair.
Certainly, Senator.
I know in Portsmouth, we have a busy inspections department, and so in terms of the timing, I understand the request, and I think the procedure laid out here is reasonable, but I think just kind of trying to sync up the changes you have in E with B, essentially what you're asking for is one time per year a GC for a project could ask for this sort of inspection within 10 days to reduce the bond. That's the request.
Either once in 365 days or when a substantial amount is done. So within, let's say that because we have a very short construction period here. Roads have to be built between April and October, and they have to be paved in November, period, end of story. So it might be where you have a significant amount of work done, you might ask for a second one.
Yep.
But by law, they only have to request once, or if substantial amount of work is done.
Okay, that answers my
And
technical question.
I know some of these timelines here, these 10 days, these 2 days, I'm flexible on those things, as long as it's not, I'm going out a year in Bedford here and 9 months in Lebanon.
Yeah, yeah. Okay, thank you very
All
much.
right, I
Thank you,
do have
Chair.
a question, but Jills, you either need to sit or step up. Please. We'll get back to you then as soon as we can. All right, the questions I have is page 1, line 20. It says not allowed for engineering, administration, or other reasons. I think that either needs to come, the other reasons either needs to come out, or other similar reasons or something, because other reasons isn't gonna hack it.
Senator-
Because that could mean anything, and then you create a conflict with what you're trying to do before. On page 2, line 6, 10 business days for a lot of the communities, especially, if there's snowstorms or other things, 10 days isn't gonna do it for me. That needs to probably go to 30 days. And then your 10 days down in line 10, okay, whether or not they resubmit for the approval or whatever, there is really no restriction on them, how long it would take for them to come back and say, yeah, I've done what you wanted to, so I don't understand why that's in there at all. I'll let you respond, but I am trying to get back on schedule here, so.
Your first comment about not wanting or other, the problem we have, Senator, is the law states right now it can be 10%, period. And they come up with, as I provide you examples, engineering, contingency, adjustments, escalation. So where do we stop it? If we say it can't be for some of these allowed for engineering, administration, or other reasons, we'll work with you to try to figure it out. But right now, they're just going around it anyway.
Engineering and administration are not construction, okay? So that's why I suggested the word or similar reason, that it's not construction. Again, I'm not trying to solve it here. I'm
Understood.
just trying to point out my concerns so that, after this meeting, that they can be addressed by you guys and you can get back to us.
I'm willing to make that change. And some of these time periods I'm happy with tweaking those as well to give you the time needed. You're right. Some of those are not appropriate time periods.
Additional questions? Thank you very much.
Thank you.
And
Senators.
the Honorable Mr. Clegg.
Thank you, Mr. Chairman, members of the committee. Thanks. My name is Robert Clegg, and I'm here actually representing the New Hampshire Home Builders Association, which I'm a member. But what I'm passing out is an actual sheet for guarantee from the town of Hudson, so that I have to post this bond so that they'll actually register my plat. They won't allow my plat to be registered. I'm not doing anything, but I have to give them a bond for $92,000, and I'll run you through it. They want me to bond the sewer. I'm not building any sewer right now. I'm not doing anything. And you can see the cost that they want me to bond it at. Then they want me to bond the bounds and pins. I'm okay with that. I didn't get the stuff done. We didn't put the granite bounds in, but they want me to $8,000. They want me to bond $10,000. It's a $1,500 to $2,500 job, but they want me to bond that 10. And when you look at the mobilization and all the rest, they come down to $92,950. Now, this is for things we're not going to do. One of the things this bill does is it says is that I can start my roads, I can start my water, and I can start my sewer. And I get a bond when I start building something that people can inhabit. Because prior to that, I'm not using the sewer. The whole idea is, as you said, I'm supposed to place a bond, so the first person that buys a house knows that no matter what happens, everything has to be completed. I'm gonna tell you where this goes. I build workforce housing. I build family housing. Cost of this is going on to the cost of the house. And I was never so disgusted as I was the last two houses when we did the numbers. We had to sell them for $500,000 in order to make 8%. That was all we made. And it's these kind of things that get added in. Every time they squeeze me, there's a check for the fire department, there's a check for the school, there's a check for the possibility that somebody might build a road. And I'll tell you, on this project, we designed it as a private road, and they came back and said, no, we've decided we want it to be a town road. So we redesigned it, we re-engineered. And after we got done engineering it, DOT from the town came down and said, I don't want any more roads, I'm not gonna approve this. So we had to re-engineer it again to be a private road. Every single time they get away with doing whatever they want, it's a cost put on the families. So I'm just saying that this bill does what we need to do. I know you have a problem with timelines, but I will explain that as we build roads, sewer, and water, they're inspecting on a regular basis. So the 10 days is basically so you can release my bond. So if you don't find anything wrong, you shouldn't be able to continue to hold it for 365 days. And that's exactly what they do. They'll hold the bonds for the roads that are completed and already, everything's been approved, and the water and the sewer. Now, remember, this is a private road, so I own everything. I own the sewer. The only thing I'm giving them is the water, because the water company said, we want to own that, we want an easement, and we want to own the pipe in case one of them breaks. So we're good. But everything else I own and have to keep control and keep fixing. So why do they need my money? And like I said, you can see it's $92,000. So, thank you.
Questions from the committee? Seeing none, thank you very much. Last one on my list is Notch.
Go for it. Thank you, Senator. Nate Grace for the Municipal Association. We do oppose this legislation. I'm not going to repeat everything that the chair pointed out. Those were our concerns as well. Realistically, the major concern that we heard from our membership was essentially what happens if a developer doesn't end up finishing the development. It's kind of the municipality that's in the bind here that has to do that. And so that was why we were concerned about the changes being made to the this bonding statute. In addition to the timeline provisions, it sounds like the sponsor is willing to work with us on the timeline, so I will be contacting him and seeing if we can come to some sort of agreement on that.
Questions from the committee? Seeing none, thank you.
Thank you.
There may be another sheet, I don't know, but is there anyone else that thinks they've signed up or wanted to speak? We should check the other in case somebody didn't get a chair. All right, and seeing none, we'll close the public hearing, and as soon as we're ready, we will open the public hearing on the next bill. Next bill on the list is Senate Bill 84. And we have the prime sponsor right here. Come on up then.
Good morning. Good morning, Chair Gray and members of the Senate Election Law Municipal Affairs. I actually have an admission to make. I went to the State House because the last time I testified before this group, you were in the State House. And I went into the room and I'm like, this doesn't look like my hearing. So, and I am, well, and I'm glad to be here. So for the record, my name is Sue Prentice. I'm a state senator from District 5, representing 15 communities spanning a large part of Grafton, part of Sullivan, and one community in Merrimack County. This was a request of the town of Plymouth, and I come before you today in introducing Senate Bill 84, which would amend RSA 7223 by adding a new section that includes a commission to study property tax exemptions for charitable organizations. Since 1996, the governing body of a municipality may enter into negotiations for a voluntary payment in lieu of taxes from otherwise fully or partially tax-exempt properties and may accept from such properties a voluntary payment in lieu of taxes. Pilots are not always formalized by contracts, sometimes taking the shape of a one-time gift to a community. But again, I'd like to stress that these are voluntary and that there is limited precedent in New Hampshire on these agreements. Understanding that these are subject to local considerations, each community working one by one on these agreements enabled in statute and with limited precedent, I believe it's realistic for us to form a study committee to learn about these pilots and the documents and to document these practices. Having been a city councilor and a mayor, I have had exposure and experience in working on quite a large pilot program in Lebanon, New Hampshire. I'm not seeking to fill any gaps in municipal budgets or to pass a law that could limit a not-for-profit in a way that takes away from the services that they offer each day, but to help this body and New Hampshire to understand how pilots work, and if necessary, and I stress only if necessary, to offer legislation that could strengthen the position of not-for-profits, municipalities, or both. I know Senator Gray, there's a committee amendment that Grant shared with me that has to do with the composition of the commission, I believe. I'm not introducing that at this time, I'm just recognizing that I have a copy of it. And it would.
For the record, that is 2023-0333.
I think, when you exec. Right, correct. I wanted to recognize that I had that. I also, with me today, have a town selectman from Plymouth, Representative Bill Bolton. He's also a member of the House of Representatives here to speak to their experience and requests. So at this point, I'd like to close out my testimony. I'd be happy to answer any questions that I can, and if not, I would get back to you. Thank you.
All right, questions from the committee? Seeing none? Mr. Bolton?
Thank you. Taking my coffee.
Chairman Gray, Vice Chair Murphy, and members of the the Senate Election and Municipal Affairs Committee. Thank you for taking my testimony on Senate Bill 84. I am a New Hampshire representative, and I'm one of 3 state reps representing Grafton House District 8, serving Plymouth, Holderness, and Ashland. I live in Plymouth, and in addition to being a state legislator, I've also been in the Plymouth Select Board for 4 terms. And Plymouth is a beautiful small town, but it's also bordered by 93, Route 3 and 3A, and Tenny Mountain Highway. And because of that, Plymouth provides easy access to serve many surrounding towns and communities to our north, south, east, and west. In terms of land ownership, the largest entity in Plymouth is Plymouth State University and PSU and the university system.
Representative?
Yes.
We do have the testimony, the written testimony, so it's better for us if you paraphrase your important points so that we can
Sure.
get through it.
All right. So I was about to say PSU is protected by statute and the university system, so they do not pay taxes or do a pilot with the town of Plymouth. Additionally, we have several entities that are all nonprofits, and the kicker is that more than half, or 53%, of the properties in our town are owned by nonprofit entities, and they're exempt from paying taxes. And I think my message here was that the fact that the town of Plymouth is obligated to provide, water and sewer, police and fire, emergency services, to any entity in the town. And in reality, we have 46% or whatever of the town that's actually paying for that full complement of support that the nonprofits are receiving. So the gist of the bill, at least in my opinion, is that we're seeking that at least the bill, when passed, would create a commission that would address our pilot agreement, or theoretically pilot agreements with our entities that are not paying any taxes at all in Plymouth, and at least establish a process to perhaps look at that process.
Okay.
So,
Questions from the committee? Just a note that generally water and sewer are billed separately by usage.
that's true.
And that the installation of water and sewer lines are also usually the obligation. So if you talk about this in the future,
Okay.
you may want to think about your testimony and not talk about water and sewer because it's not applicable. Fire, police, are all,
Emergency services.
game
Yep.
services that would apply.
That's a good point. Thank you, Senator Gray.
All right.
I have a question.
Senator Murphy.
Thank you. Representative, 53% is what you said, owned by nonprofit businesses and organizations, but does that include the high school, the elementary school, the Grafton County Services Center, the Armory?
That does include those, and
So-
and also I brought some example. Actually, I brought the document that shows all the nonprofits in the town. But yeah, it does include those and many others.
One follow-up?
Absolutely.
Thank you, Mr. Chairman. So, I mean, is it your kind of vision or hope that those state, local organizations would be paying pilots? Or out of the 53%, how many of them would you foresee would be paying a pilot potentially?
So realistically, I don't. Like the excuse me, National Guard Armory or the university. Well, the university is not in that 53%. So some of the entities that are exempt by statute would not be paying a pilot. But I anticipate, the commission would look at all the entities and decide what, types of entities might be able to, support a pilot.
Thank you.
Senator Adams.
Thank you, Mr. Chairman. And if you don't know this off the top of your head, just please email the information later. What is the tax rate currently in Plymouth?
Thank you for asking that question. So we're at 31.29 per thousand, and it's anticipated. We're going through the budget process now, obviously, and we're anticipating an increase of about $4. So we're going to be, pushing 36 per thousand, which my finance director in Plymouth indicates that might be the highest, and I'm really not enthusiastic about getting the highest. So,
Additional questions?
all right, thank you.
All right, thank you very much. To get a little balance, we'll skip down the list to Kathleen Reardon.
Good morning, Chairman and members of the committee. Thank you for having me here. My name is Kathleen Reardon. I'm the CEO of the New Hampshire Center for Nonprofits. With more than 700 nonprofit members across the state, we work to strengthen and give voice to New Hampshire's nonprofit sector. And we are here to express our opposition for this study commission. As you all know, nonprofits provide critical services in partnership with government in our communities. And in New Hampshire, perhaps more than any other state, we really rely on our nonprofit sector. We've seen this extensively throughout COVID about that partnership with nonprofits providing things like affordable housing, childcare, healthcare, education, really vital community services. And the property tax exemption has been a longstanding policy that helps nonprofits who are, for their mission-driven work, apply for that exemption each year. And in some cases, particularly with larger organizations, they do enter into pilot agreements with that municipality. And that is a local negotiation that is really highly dependent on the needs of that community and the considerations of that nonprofit. I would also want to point out that this is, a really tough time for many organizations, as nonprofits are seeing increased needs from their communities, as well as, like everyone else, increased costs and pressures with inflation, high cost of housing, the workforce shortage, and that. So this is a really important time to bolster our nonprofit sector and not add additional burdens on them. Most nonprofits in New Hampshire are relatively small, and they have very low administrative overhead. So adding additional cost structure would put burden on nonprofits. This is not the time to study that. We also don't think that this is an appropriate study commission for the state. These are local voluntary negotiations, and that they're, while a study commission may seem benign, it is not the place of the legislature to do this. So we would hope that you'll find SB 84 inexpedient to legislate. And I'm happy to take.
Seeing none, thank you very much. Catholic Charities, Tom.
Good morning. Thanks for having me. My name is Tom Blonsky. I am the president and CEO of Catholic Charities New Hampshire, and I'm speaking this morning in opposition to Senate Bill 84. Since medieval England, nonprofits have always been exempt from paying property taxes because they relieve the burden of government. Nonprofits provide essential, critical, and life-saving services throughout the state. We as Catholic Charities provide job training, life plan development, education services, food distribution, transportation services, mental health counseling, immigration legal services, transitional housing for vets, for single moms, for seniors, multiple nursing home operations. We serve 1 in 12 people throughout the state. If not us as a collective nonprofit industry, then who? Many of our clients turn to us who have been turned away from local welfare departments only to request assistance for rent or other services that should be managed by the city, in a sense. We offered $22.22 million worth of free or reduced services to those in need around our state. So if a pilot were to be enacted, nonprofits would continue to be asked, as we're continuing to be asked to do more with less, having to fund the shortfall of government dollars for the programs that we offer. Pilots would take away monies from our ability to fund programs, taken away from our mission, and there's a disincentive for donors to want to donate to nonprofits if their monies are then going to pay for taxes or governmental fees. One last thing I'd like to make a plug for is we run 7 nursing facilities in our state. For every Medicaid resident we accept, some of our facilities as far north as Berlin, we have 82% of our census is Medicaid residents. We lose $75 per Medicaid resident per day. We are number 47 out of 50 in terms of the lowest funded Medicaid in New Hampshire, in the United States. So my sense of a pilot tax for our organization would be the equivalent of someone behind me at a precipice pushing me over the cliff. This is where we are right now with many of our funded programs. Thank you.
Questions from the committee members? Seeing none, thank you very much.
Thank you.
Nat?
Thank you, Mr. Chair. Nate Graves for the Municipal Association. We support this bill. We actually have a specific policy at the association that was adopted this past September by our members asking us to support legislation like this because there are questions at the local level about the definition of charitable and how that applies in instances. And so our members thought it was appropriate to request the legislature create a commission to study this area. And so we do support it, and I'm happy to take any questions that the committee may have.
Questions from the committee? Seeing none, thank you very
Thank
much.
you.
Paula Minahan.
Good morning, Mr. Chairman, members of the committee. For the record, Paula Minahan, Senior Vice President, State Government Relations for the New Hampshire Hospital Association, representing all our hospitals, our community, as well as specialty hospitals. We are opposed to this bill, and this bill was introduced. We've seen this bill numerous times, the last one being in 2020, and we have opposed these efforts every single time. Hospitals in New Hampshire are driven by a mission to provide high-quality care and improve the health and well-being of the communities they serve. I will not read this testimony because there's a lot here, but I do encourage you to please review it, and I'm happy to answer any questions. I want to point out I've attached our community benefits report, and let me just find that. We have last year, or the last year that we collected this information, there was the hospitals in New Hampshire provided over $594 million in community benefits, and you will see that there's over almost $400 million that included financial assistance to patients at cost and the value of unreimbursed Medicaid services, and almost $200 million in other community benefits. To Mr. Bolonsky's point, you take the nonprofit and you require a pilot, some of this will go away, which is very troubling. Another document is our fact sheet that shows that hospitals statewide provide 43,000 jobs that contribute $4.2 billion to the economy. When coupled with 37,000 jobs that are generated by the local economy because of the hospital's presence, such as pharmacies, nursing homes, DME, doctors' offices, et cetera, that adds up to over $6.4 billion to the state's economy. So jumping down to the end of my testimony, we believe strongly that decisions about a community and nonprofit hospital and other entities should enter in a pilot is a local decision, and I think you are aware that many hospitals do enter into these voluntary pilots throughout the state. However, again, these are based on local community needs and decision makers and more. We are concerned that this study commission could create the expectation, and I think this is what Ms. Reardon was getting to, that nonprofits exempted from property taxes would be required to enter into a pilot. We do not believe this type of mandate from Concord is the right approach. We believe the best approach is to leave those decisions to local decision makers and determine how best to serve their communities. Thank you, and I'm happy to answer any questions.
Questions from committee members? Seeing none, thank you very much. If you check to see if there's anybody on the additional list. Is there anyone out there that signed up to speak or wants to speak now? Seeing none, we will close this public hearing and we'll open the next one as soon as we're ready.
When this was transportation, the room seemed really big.
Okay, and we'll open the public hearing on Senate Bill 132 and ask the prime sponsor to introduce himself.
Thank you, Senator Gray. I am Senator Bill Gannon. I live in the heart of the wine district of New Hampshire, Sandown, New Hampshire, and I present for your viewing SB 132. Over the last 2 years, the United States has saw disastrous border policies that have caused disreputable harm to towns and cities across the United States, including New Hampshire. My constituents asked me to bring this bill forward so we can stop this from, if you stop one drop, you stop something somewhere. So we're going to try to deal with it in New Hampshire, as our federal government has ignored the issue. A little background, I'm very pro-immigration. My grandparents came from Ireland. They came at young ages because they had horrible lives, living in almost cave-like settings. In the summer, they'd go work and cut stone wheels for quarries. And they looked at us as the land of opportunity. They came over here at the ages of 16 and 18, and they had sponsors, and we dealt with immigration properly. A sponsor would take care of you and be responsible for you to work and support yourself. Unfortunately, we don't do things that way anymore. SB 132, what does it do? What doesn't it do? What it doesn't do is force towns to do anything in New Hampshire. It just stops them from, we want people to cooperate. We're not telling you you have to enforce federal law. We're saying that if a federal agent wants to execute a detainer, that we want you to go along with that. And so why are we doing this? Well, we've had people like in 2020, we had, I'll just use the first name, Carlos. He raped, kidnapped, and sexually assaulted women in New Hampshire and Massachusetts. I can give you a list of other examples of people who were on a deportation list who in New Hampshire have committed crimes. In New Hampshire at our northern border, we have had, the encounters are up 197%. So while we have a porous southern border, we now have a porous northern border because, and that's dangerous for the immigrants looking to come in because we just had terrible weekend conditions of weather. In a 3-day period in late January, the 29th, 30th, and 31st, I believe, we had 39 people trying to sneak across the New Hampshire border. Weather conditions weren't quite as bad as Saturday, but they were bad. And so we're putting these people at risk just like we are at the southern border. They're going to starve or die from the heat exhaustion. They're going to get sold into slavery when they come here. So there are just, the repercussions are endless. It's part of our drug problem. In the last year we had, the last 4 months we had 300 pounds of cocaine, 500 pounds of fentanyl, 4,500 pounds of methamphetamine. A lot of it's carried in by unfortunate immigrants who want to come here and they can't afford. We have a DEA agent who's going to testify that most of the people coming on the southern border are paying $30,000 to $50,000 to coyotes to come over. And then they owe them. They know their family's still back at the other country. They have to act as sex slaves. The problems with this are just endless. So it's an area that Governor Sununu has said he is going to use our police to help enforce the laws that aren't getting done federally. And enforce is the wrong word. I shouldn't have used that word. We're just going to cooperate. We're going to work with the federal agents, and if they find out that someone that they have at a stop, they detain them. They find out that they're wanted and that there's a detainer notice for them. They're going to cooperate with ICE. We just do not want people to. We want to discourage, prohibit, and limit people from coming up with their own decisions. Then we're going to have sanctuary cities. We just want cooperation. Again, we don't want to be the federal. We're not enforcing a federal law. We're just cooperating with them. We cooperate with them in other areas. We do it on. There's a street in Nashua where most of our drugs come through, as Senator Abbas probably knows. We cooperate with federal officials and DEA agents. We do. What else do we do? We do civil asset forfeitures with federal agents. So it isn't unknown that our government agency statewide cooperates with federal agencies. And so this bill is really just looking to do that. No sanctuary policy. We're not mandating that. We're just encouraging, limiting, and discouraging sanctuary policies. A number of towns, at least 12 towns and counties in New Hampshire, either have written or practice sanctuary policies, and we want that to end. And the reason is the health, safety, and welfare of New Hampshire citizens are at risk when we have aliens in our state. And again, most are probably well-meaning. They want jobs like my grandparents, but again, last year we had, again, 3,000 criminal convicted people were apprehended at the border. 10 were murderers, 76 were sex offenders. We don't know who the million people were who came through, what percentage of them were dangerous. So if the federal government is doing its job and says they want us to detain someone, it's a 48-hour detention at the maximum, then you would be let go if they failed to pick up. But I feel it's a minimal step to help ensure the safety of New Hampshire citizens. I have a lawyer, Ms. Randell, who's an expert at this area of law. So constitutional questions, you might hold off for her. I was just setting you general policy. There are a bunch of state representatives who are going to testify and put more of a face, a human face, on what's happened in New Hampshire, where there have been police stops, and there have been towns that are scared to detain someone for fear of a lawsuit. So they'll put a more face on the bill. And I think the attorney will have better legal answers than I do, and I think the representatives will have more personal cases to answer. So if I could defer questions to them, I would, as they need to be back in commerce working on minimum wage, but I would entertain any light questions.
Questions from the committee? Thinking none.
Thank you very much.
With the representatives that are here's permission, I'll go to Sherry first, since the prime sponsor asked. If that doesn't fit your schedule.
I have another bill that's.
Okay, Representative Notter.
Thank you.
Thank you. Thank you. Have a good day.
Good morning, Senators. For the record, I'm Janine Notter. I represent the town of Merrimack, Hillsborough 12. And I was a freshman representative with Senator Murphy back in the day. So this isn't the first time the New Hampshire State Legislature has taken up the issue of sanctuary city policies. The year that I sponsored a similar bill, I had several conversations with a retired senior special agent of the Immigration and Naturalization Service, Michael Cutler. The words and information in the following testimony are taken from Agent Cutler, retired. The borders of the United States are its first and last lines of defense against the enemies of our nation. This includes spies, terrorists, saboteurs, and international terrorist organizations. Our borders are supposed to protect America and Americans from aliens who suffer from dangerous communicable diseases and severe mental illness, as well as transnational criminal and narcotics trafficking cartels, human traffickers, and fugitives from justice. Sanctuary cities obstruct ICE agents and shield said human traffickers and drug smugglers. When this bill was heard before, there were some who took exception to the use of the term alien. It was the Carter administration that demanded that INS employees replace the term illegal alien with the term undocumented immigrant. As a consequence, over time, the public understanding of our nation's immigration laws has been seriously skewed. The term alien is defined by the Immigration and Nationality Act as any person not a citizen or national of the United States. There is no insult in the term or in its definition. It is noteworthy that the DREAM Act is an acronym that includes the term alien. It stands for Development, Relief, and Education for Alien Minors. It is vital to note that our immigration laws make absolutely no distinction in any way, shape, or form as to the race, religion, or ethnicity of any alien. They come from all over the world. The term sanctuary conjures up a comforting image of a place of security and serenity. In my own words, the term makes me think of refugees crossing the border to escape tyranny, and those who would halt their arrival as unchristian and uncharitable. In that respect, I can't say that I disagree. Correct me if I'm wrong, but I believe that falls under political asylum, and this bill is not about political asylum. Agent Cutler said, the only people who truly benefit from sanctuary policies are transnational criminals, international terrorists, human traffickers, and drug smugglers. And the last thing I want to say is that every other country in the world protects their borders, and we should too. Thank you.
Questions from the committee? Thank you very much. Is there any other representative that has a schedule conflict? Because I do want to get to the attorney that the prime sponsor asked for. Okay. Sherry.
Give you written
testimony as well.
And again, just reminding the audience that if you have written testimony, I don't need to be read to. I can read it on my own, so please paraphrase it, keeping it as brief and hitting the salient points.
Good morning, Chairman Gray and other distinguished members of the committee. Thank you for allowing me to be here with you on behalf of SB 132. Just a little bit of background. The Federation for American Immigration Reform is a nonprofit, nonpartisan organization of concerned individuals who believe that our immigration laws must be reformed to serve our nation's interest. We have been around since 1979. We have 3 million members and supporters nationwide. We have 4,000 in the state of New Hampshire. And FAIR opposes the reckless lawlessness that sanctuary policies establish. And we recognize that SB 132 is the way to end these policies. There are a couple of points that I do want to hit. Sanctuary policies shield criminal aliens. They're public safety and national security threats. I want to start with the fact that while everyone who comes to this country illegally does not intend us harm, I recognize that. However, those people who are coming through our back doors have not been vetted, so their intentions are unknown. Even those people who have entered legally, such as students or those who are on tourist visa and overstay their visas, they do not go through the same background as someone, for example, a refugee who is coming to this country who's been thoroughly vetted. Even more distressing, as Senator Gannon mentioned, is the fact that our borders are porous right now based on the immigration policies of this administration. According to U.S. Customs and Border Protection, in fiscal year 2022, 98 individuals on the terror watch list were encountered at our southern border between ports of entry, and 67 were encountered at our ports of entry. On the northern border, at the port of entry, we had 313 individuals. I was talking to a deputy chief yesterday. He was briefing some sheriffs. In fiscal year 2023, there were already and that starts October 1 till February, there have already been 775,000 encounters. People from 135 countries have been trying to enter our borders illegally. 3,000 of them have serious criminal convictions, including 10 homicides. But on the flip side, what most people aren't talking about are the 835 individuals who died crossing our borders. We understand people are desperate and they want to come to our country, but there is a human side of this as well. It not only impacts our communities, but it impacts those who are coming across. I can tell you a sheriff in Arizona talks about garments put in their trees when women are coming across raped. We know that parents are giving young children drugs to prevent pregnancy because they know they'll probably be sexually assaulted. We know that it costs between $30,000 and $50,000 for some countries to come across this border. The cartels are controlling our border. Not one individual comes across our southern border who has not been paid to the cartel. Sanctuary policies come in all shapes and sizes.
The bill actually talks about banning localities.
Sanctuary policies, yeah.
So
You want me to focus on
I
that?
know,
Yeah.
you know, we've got enough background now, I think. We need
Perfect.
to speak to the bill itself.
Okay, well, sanctuary policies, some are written, some of them are not. Some of them masquerade as welcoming policies, and basically what they do is they prohibit or discourage local enforcement of from asking someone who's lawfully stopped or detained about their immigration status and from otherwise cooperating or communicating with officials. And regardless of how they're adopted or what form they take, these are putting greater emphasis on the welfare of illegal aliens than the safety of our citizens and residents in our own communities. And we've seen hundreds of cities and municipalities nationwide implementing these types of policies. Since 2017 in New Hampshire, there have been a proliferation, including Cheshire County, Deerfield, Dublin, Durham, Hanover, Huntsville, Lebanon, Lyme, and Manchester. And in most of these cases, those localities are not calling themselves sanctuary cities, but their practices are making them function as a sanctuary policy. And so SB 132 will ensure that these jurisdictions cannot prohibit or restrict communication. One of the things we've heard from proponents is that by enacting SB 132, law enforcement will be discriminating against minorities. I want to make it clear in this bill that this is not addressed in this bill. And in fact, what is specifically said is that it prohibits discrimination, saying that a state or local government entity shall not consider an individual's race, color, religion, or national origin. So this is something that is specifically written into this bill. Unfortunately, what we see is that Massachusetts is mostly a sanctuary state. You all border that. Massachusetts is a gateway for drugs coming into this state. And we know that in October 2018, there were dozens arrested on federal drug charges and immigration charges. Authorities have seized 10 kilos of fentanyl.
We need to get back to the bill again. We're going back to history.
Okay.
And
basically, sanctuary policies rely on the fact that people are here and they're generally law-abiding. So they simply want to encourage people in their communities. Unfortunately, what we see is that the average adult will commit multiple crimes just to conceal their legal presence in the United States and work without authorization. So these policies, what we're trying to do is ensure that we're not shielding folks and making it easier and more of a magnet for illegal immigration in the state of New Hampshire. The other thing we hear is that this bill will encourage New Hampshire officers to enforce federal immigration laws. That's not the case. Law enforcement officials do not enforce bills. The only time a law enforcement officer in the state would enforce immigration laws to a limited extent would be if an officer is a 287G officer, and I do not believe there are any local law enforcement that are 287G. What we're saying is, in this legislation, only that cooperation cannot be prohibited. With respect to detainers, I know that Senator Gannon mentioned detainers. Detainers are simply requests to law enforcement by another law enforcement agency to hold an individual for up to 48 hours, period. So we know that if the officers are detaining an individual at a traffic stop, for example, if someone in Dover stops someone and detains someone, they are doing it on a state issue, not on their immigration issue. It's only once they have contacted immigration officials and have received a request that they would hold them for the 48 hours. I want to kind of clarify that because that has been an issue in the past. I will wrap it up and allow questions if that is better for you.
questions from the committee members. Senator Abbott.
Thank you, Mr. Chairman. As written in Senate Bill 132, does this permit local or state police to detain or pick up or arrest someone or take someone into custody because there's an outstanding detainer request?
So most of the time, they're not going to arrest or detain someone on the street. They'll book them for their state issue and then receive the detainer request. And when they do, it's just simply that. It's a request to hold. They receive requests all the time from the U.S. Marshals and other law enforcement officers. This is not mandating that they do that, but it prevents them from being prohibited.
Follow up, Mr. Chairman?
Yes, sir.
So this would apply to in a situation where a person's already in custody.
Most of the time, generally, it does.
Most of the time, or
It's not always that it's that way, but most of the time they're in custody. They've been stopped for or detained for another issue, and then their status comes up.
but could there be a circumstance where someone lives across the street from this building, we'll say, and if there's a detainer request, would this permit law enforcement in Concord to go take that person into custody because of the detainer request?
No, so you're saying if somebody lives across from an individual and they're going in?
I'll rephrase it. If there's a person who's not in any type of custody right now, but there happens to be a detainer request issued for that person, would the police, the local law enforcement officers, be able to then take that person into custody because of the detainer request?
Generally speaking, I think that ICE would do that themselves if there's a detainer request. Usually speaking, they're not going to go out and just wholesale arrest people.
Thank you. One more follow-up, Mr. Chairman.
Certainly.
And does this permit police to use its discretion on a case-by-case basis with a person as opposed to mandating one policy or over another? Meaning you can't be a sanctuary city, but you don't necessarily have to comply with the detainer request?
Yes, that is correct. They don't have to comply. It is not mandatory under this bill.
Thank you.
Additional questions? Seeing none, thank you. And if the representatives would further let me get a little balance, I'll ask Jills to come up and do the testimony so that we hear from the other side.
Thank you, Mr. Chairman.
Welcome.
You have some written testimony as well. That's helpful. Thank you.
And as said before, paraphrasing is good.
I know your rule. I want to respect that very much. And I know this is a complicated bill and a complicated issue. And want to convey on behalf of the ACLU, again, my name is Gilles Bissonnette, the legal director here, that we are in strong opposition to this particular legislation. And I have 3 points to make, and I'm going to ground my points in the text of the bill, because I think that's incredibly important. And Mr. Chairman, you've, I know, wanted to focus us to the text of the bill. But I do want to stay at the outset, the conflation between immigration and criminal behavior, which, you know, I've heard this morning. I hear a lot kind of out in the ether. There's some great data from the Cato Institute that really rebuts a lot of that, and I'd be happy to circulate that to the committee. But the points that I want to make is at the outset, this notion that this isn't a mandate is just not true, in my view, when you look at the exact text of this particular statute, particularly when you look at page 2, lines 19 to 20, page 2, lines 24 to 27. Any policy that in any way limits, prohibits, or discourages cooperation with federal agencies would be banned under this. Any policy that restricts in any way or imposes any conditions on or cooperation with immigration detainers would be banned under this. And any policy that requires the federal immigration agency to obtain a judicial warrant would be banned under this. So the discretion is cabined considerably. If you get an immigration detainer under this, you need to hold that person under this. If you don't, you would have under this language limited or discouraged cooperation with federal agencies, and you would have imposed a restriction, even if it was in a discretionary basis. You would have imposed a restriction on compliance with the detainer. So I just think respectfully, that is just wrong. What this bill does is essentially require local officials, again, the text does this, to engage in immigration enforcement. And I would just submit that this is a significant intrusion on local control. And frankly, the notion that in New Hampshire, we don't demand that our local towns do the bidding of the federal government. And the legislature took that position last year with respect to HB 1178, with respect to firearms. This is the opposite of that in the immigration context, requiring localities to engage in immigration enforcement. I do also want to say that this bill effectively requires state and local governments to honor and enforce immigration detainers, as I noted before. And this is problematic, and I'll explain why, and may even force state and local governments to violate 4th and 14th Amendment rights. This is because immigration detainers are not arrest warrants. What they are, unlike criminal warrants, which are supported by judicial determination of probable cause, ICE detainers are issued by ICE enforcement officials themselves without authorization of a judge. That's just how the process works with respect to ICE detainers. And I do also want to flag that it is well settled that a person's presence in the United States in violation of immigration law standing alone isn't actually a crime. Immigration violations are generally civil rather than criminal in nature. So in light of all of these principles, many courts throughout the country, we cite them in the testimony, have explained that ICE detainers are not based on probable cause. And even in the absence of a detainer request, many courts have concluded that state and local enforcement officers may not detain or arrest an individual on their own initiative based on known or suspected civil violations of federal immigration law. Again, because standing alone, an immigration violation is civil and not criminal. So I think when a local police department now looks at this bill and says, gosh, I have a detainer, I just engaged in a stop, but then they decide to prolong the stop based on a suspicion of an immigration violation under this bill, because if they don't do that, perhaps they're violating this bill, they have now run the risk of potential 4th Amendment liability. And I think that is just such a thorny issue that the legislature doesn't necessarily need to wade in on. And I think, again, it creates potential exposure for our government officers on the ground. Lastly, I just do want to flag that I think this bill would undermine and harm public safety. And the reason I think that is because it is important that everyone have access to police, to report crimes, to report their victimization as a result of domestic abuse, to help police solve crimes. If you fear under this that anytime you engage law enforcement, that you're going to have an interaction with police with respect to your immigration status, and perhaps worse, that it could lead to ICE detention, you are just not going to have that conversation. You are not going to engage police. And I do want to highlight the testimony of one police chief that has been submitted to this committee on that very point. And I want to just kind of flag a very specific example of this to conclude my testimony. And that's a case that I litigated out of Exeter. And there was an individual who works at a gas station. He actually wasn't working that day at the gas station. The head of the gas station was involved in an interaction with a woman at the gas station. It led to the police to be called. And my client showed up and actually translated the conversation between the police officer and the individual. And as a result of that communication, the individual was arrested. So I mean, our client did a good thing. He helped make sure that information was conveyed to the police so the appropriate action could be taken. After that interaction, the police then turned their attention to him, started inquiring about his immigration status, and ultimately led to ICE detention. That is the type of thing we actually should be concerned about, because individuals are just not going to communicate, not help law enforcement if bills like this are on the books. So with that, I'll conclude my testimony and want to thank everyone for their time. I appreciate it very much.
Thank you. Questions from the committee members? Senator Perkins Coker.
Yeah, thank you so much for being here, Jill. So I do want to clarify, a point I think you made effectively, but essentially what you're saying and what some of the testimony we've received from police chiefs here says is, the language of this bill, the plain language of the bill, could really put our local law enforcement officers in a situation where they are detaining people without probable cause, because it's not required to be established for an immigration detainer. And so
Not probable cause that a crime has been committed.
okay.
Yes.
And so that puts them at risk of committing a Fourth Amendment violation simply based on the burden of proof.
Yeah, absolutely. And it's just in basic I didn't mean to interrupt you, Senator. I'm sorry.
No, you didn't. You probably reached the end of my sentence there.
Just based on the fundamental kind of concept, right, that that immigration violations generally, I'm not talking about unlawful reentry, different thing,
Yeah,
right?
yeah.
But an immigration violation, being in the United States, say on a visa overstay, for
Yeah.
example, is not inherently a criminal offense.
Right.
Civil immigration violation, yes.
Yeah.
But that's where this creates kind of thorny
The
legal
ambiguity,
complexities, right?
sure.
If you have local police detaining someone exclusively for a federal civil immigration violation,
Right.
that does create some potential concerns
Right.
that I think, which is one of the reasons I just think this really should be set
Serious.
aside and more carefully evaluated.
Yeah, okay, thank you.
Senator.
Thank you, Mr. Chairman. And I asked this question to the previous
Sure.
witness, but I'll ask you as well. By just reading this, do you interpret this Senate Bill 132 to permit local or state police to take someone into custody that's not already in custody?
To take someone into custody that's not already in custody, I don't know, reading this bill, actually. This bill is just governing policies. It doesn't say, for example, affirmatively local law enforcement can arrest for federal civil violations. It doesn't say that. It's simply addressing policies that municipalities may or may not enact with respect to immigration, detainer, and federal cooperation. So I guess my question is, I actually don't know the answer to it based on at least my read of the bill.
Thank you.
Thank you.
Additional questions? Seeing none, Representative Piemonte.
Thank you.
Thank you.
Thank you, Senator Gray, and thank you for the committee for hearing my testimony. I'm basically going to be brief with this. I supported the bill because of national security, public safety. This morning I was listening to the governor, actually, on the radio, talking about our northern border. A northern border consists that affects New Hampshire would be New York, Vermont, and New Hampshire. He said there were over 40,000 people that have crossed our northern border. Also, some of them are going through the woods, avoiding all the checkpoints and things like this. And this is something that you don't know who these people are. We don't know where they're going or what they're doing. And if they go to any of these cities that will welcome them, they can be lost and get their job done or do whatever they want to do. So that's basically what I'm looking at with this bill, is the national security and public safety. I think that something has to be done. There are a lot of legislatures in the country that are considering similar bills. And I think it's about time we do something here in New Hampshire to protect our citizens. And that's basically
Thank you. Are there any questions from committee members? All right, thank you.
Thank you very much.
Representative Dolan. And
Thank you,
Thank
Senator.
you both for, your delay in getting up here.
Thank you, Senator. I'll be very brief. I wanted to put a face to what's happening in our local communities. I recently left service as a town councilor in Londonderry after over 20 years of service at that level. And I've had numerous discussions with our local police force and our police captain, police chief. And what we've run into is this human trafficking issue more and more. And I can tell you, as a devoted grandfather of my grandchildren, when you come across these 12, 11-year-old girls in massage parlors, there's only one reason they're there. And it's heartbreaking to think that thought through. And God forbid if the coyotes or their folks that are helping them get into that position are hiding behind sanctuary city policies, shame on all of us. This is something that has to stop. We need to focus on it. I mean, my grandchildren are not going to be in that situation, but these young girls are somebody's grandchildren, somebody's child. And I ask for you to consider that making sure that these folks, these handlers cannot hide behind sanctuary city policies to do their craft, be fettered out through this legislation. And I thank you, and I'll take questions if you.
Questions from the committee? Seeing none, thank you very much. Natch? And whoever is standing at the door, if you'd come in and get a seat, we'd appreciate it.
My apologies, Mr. Chair, didn't want to interrupt.
Thank you, Mr. Chair, and
Christina.
H. Graves for the Municipal Association. We oppose this legislation. I won't reiterate the first point that the ACLU put in front of you, that this is a local control issue, which we obviously support local control, and that is our primary reason for objecting to this legislation. And we do also read this as a mandate. To go to Senator Abbas's question about whether someone could be taken into custody who is not already in custody, similarly, I don't know the answer to that, but that goes to my second point here, which is that we've basically been put on notice that in order to resolve this, there will be litigation. And unfortunately, that will probably be the ACLU suing municipalities who decide to take certain actions in response to passage of this legislation if it passes. I will point out in the ACLU's letter that they submitted to you, they cited, assuming it hasn't changed since yesterday, they cited the the town of Northwood, and I just point out to the committee that that case was settled for $12,500. So again, we don't want municipalities to be put in the middle of complex issues where our taxpayers and our bases will be the ones who are paying to resolve these issues that are better left to the legislature. Thank you.
Questions? I'll ask a question. Since we're not home rule, what gives the community the ability to enact one of these policies in the first place?
Well, I think this just relates to how specifically local law enforcement relates to federal law enforcement. So in my prior experience as a prosecutor, we would always work as cooperatively as possible with federal law enforcement whenever possible. There were situations where we would get calls, not specifically about immigrants, but about other issues that federal law enforcement was interested in that we as state officers didn't have powers to do anything under, but we could provide information, set up situations to assist federal law enforcement. And I'm certain that local law enforcement across the state is happy to do so because we get a lot of support from federal law enforcement.
I did hear your answer, but I didn't hear anything in there that told me that there is some provision in either state law or policy that would allow one of these communities to enact a policy that ignored federal law or other state law. Is that true?
Well, Senator, I don't think that they're intentionally ignoring federal law or state law. I think that they're trying to clarify via local policy what the appropriate approach is when it's not clear what role local officials have in that.
At some point, I may want to have a further conversation with you about that issue. So, any other
happy to do
questions
so.
from committee members? Seeing none, thank you very much.
Thank you.
And Wellington, Christina?
Good morning. Christine Wellington. I'm a resident of Derry. I'm also a member of the New Hampshire Immigrants' Rights Network. We sent a letter by email last night to all the members and sponsors. Gilles covered most of what we would also say. I wanted to point out just a very couple things. First of all, there are no sanctuary cities in New Hampshire. To my knowledge, there are no laws that mandate that police officers not cooperate with federal agencies. In fact, they do every single day. law enforcement entities in New Hampshire have also engaged with immigrant communities for the purposes that Gilles described of increasing confidence and getting people to come forward when they're victims of crime or witnesses of crime, et cetera. So we believe that if this HB 132 passed, it would damage a lot of the work that has been done, and particularly for those police departments, including the New Hampshire State Police, who have developed fair and impartial policing policies, which specifically direct their folks not to enforce civil immigration detainers because they're not judicial orders. And we think that this law would reverse those kinds of policies. The New Hampshire State Police policy, the ACLU, the Immigrants' Rights Network, worked with the New Hampshire State Police. We regularly engage with the Department of Safety on these issues. And those policies have been widely adopted. The Police Training Standards Council has incorporated that policy, as has the Attorney General's Office in their latest manual, which is the 2020 manual. So we think that that would be really problematic in continuing to engage the communities. And the last thing I will say as I listen to this is it seems very clear to me that the basis for this law is fear-mongering and overstating what's going on in New Hampshire and at the border. We know, and this is the last statement I'll say, that most of the folks that are here without permission of the United States government came in legally with a visa and they overstayed the visa. It's not at the borders. That's a problem, but that's not the majority of people that are remaining in this country. And we think there's about 14,000 people in New Hampshire that are undocumented. That's the best number that I've been able to find. And those folks are members of our community. Most of them have relatives that are lawfully present or U.S. citizens. Thank you.
Questions from committee members? Seeing none, thank you very much. Eva Castillo? All right.
Hello, thank you for taking my testimony. My name is Eva Castillo, or Eva Castillo. I live in Manchester. I guess if I pay attention to the description, I'm a former alien. I've been in New Hampshire since the 80s. Part of my job is to build trust in the community. Part of my job is to work on immigrant integration, and I see I go to a lot of police departments to make sure that we trust them. I'm a Manchester Police Commissioner, and I've been in the Manchester Police Commission about 9 years. I'm not speaking on behalf of that, and I have no rights to talk about that, to talk on behalf of the commission. So just to be clear. But I run the monthly community meetings with the police since 2011, and I've gone to different police departments. And the idea is for immigrants to feel safe contacting the police. Like Jill said, you know, people, if they are witness of a crime or if they themselves are victims of a crime, we come from places where our police are crooked, they're bad, they're mean, and they are the strong arm of the totalitarian governments. So we come here, and that's what we have in our hard disk. And it takes a while to learn to trust that. And so I go a lot, talk to immigrant communities about that and make sure that we bridge the big gap and that we change the mindsets of people. I've heard us being defined as criminals and all of that, you know, that's a minority of people. And right now, the way things are with the so-called sanctuary policies, the police, they all go and report criminals to ICE. If you have not committed a crime, that's a different story. But even the police departments that do have sanctuary, so-called sanctuary policies, they are, you know, they just keep prosecuting criminals, and they do report them to ICE, and we don't object to that. I am, we take pride in doing things differently here in New Hampshire. This bill would destroy that trust that myself, for over 20 years, I have worked really hard in trying to build on both sides. But at the same time, it's going to make all of us more vulnerable to crimes, to real crimes. We take pride on doing things our way. I encourage you to vote ITL on this bill that is just a regurgitation of a national anti-immigrant efforts to undermine the good relationships that police have made.
Questions from the committee? Seeing none, thank you very much.
Thank you.
Kevin Williams?
Good morning, Mr. Chairman and members of the committee. My name is Kevin Williams. I am a private citizen, and I am representing myself. I'll give you a little bit of my background. I recently retired after 26 years of law enforcement, 20 of which were spent with Immigration and Customs Enforcement, 12 of which were spent with ICE here in New Hampshire. I am in support of Senate Bill 132, and the reasons being are, as of right now, as far as the last testimony about agencies or law enforcement, local law enforcement calling ICE to report criminals, that's not happening. And a lot of that is not happening because law enforcement agencies are being sued left and right in this state, or were prior to COVID. There was one lawsuit specifically mentioned, and I was the ICE officer that actually responded that night. And part of the lawsuit was that there was a claim that it took over 90 minutes for ICE to respond. The gas station in question was 15 minutes from my house. It took me 15 to 20 minutes to respond, not 90. The individual that interpreted for the police department that night, when I showed up, I'm the one that asked him where he was from, and then when he told me he had overstayed his visa, that's when I told him he was detained and no longer free to leave. As far as Senator Avis's question about detaining somebody who is not already detained, local law enforcement cannot arrest somebody on an immigration charge, period. It has to be an immigration officer. When an immigration detainer is lodged, an immigration warrant goes with that detainer, whether it's an I-200 warrant of arrest for an alien or an I-205 warrant of deportation. So warrant of deportation, only a judge can order deportation. So that means that a federal immigration judge has ordered removal of that individual. As far as it not being a crime to be in the country illegally, 8 U.S.C. 1325 very specifically makes it a crime to illegally enter the United States. If you've been deported and come back illegally, it's a felony under federal law, under 8 U.S.C. 1326. I personally have prosecuted numerous cases under 1326 right here in U.S. District Court in Concord. There are very specific cases throughout the country where immigration detainers were lodged and not honored. And the result of the detainer not being honored has resulted in the murders of individuals. One of those murders was a 16-year-old girl who was murdered by MS-13 gang members. One of them had an extensive criminal history. ICE had never been notified. Another one had previously been released, even though there was an immigration detainer had been lodged against him. Everybody knows about the Kate Steinle case. That individual had illegally re-entered the country after being deported and was a convicted felon. Prior to the murder of Kate Steinle, an immigration detainer had been lodged against that individual and not honored. In the Flores case, individual, multiple felony convictions in the country illegally, had actually been deported 10 times from the United States. His crimes spanned 30 years here in the United States. Carrying concealed weapon, trespassing, burglary, disturbing the peace, possession and transportation of controlled substances, impersonation, DUIs, resisting arrest, criminal threats, and he had already done time for illegal entry as well. There was an immigration detainer in place. He was released in spite of that detainer and then became the prime suspect in the murder of Karen Ruiz. He was not arrested for it because he had ultimately committed suicide. Specifically here in New Hampshire, I have arrested one individual in specific who actually admitted that back in his home country, he was a financier for a terrorist organization. This gentleman was living in Dover, worked in Rochester, and had another job in Portsmouth, and was living illegally here in the United States. I can't tell you the number of people that I have personally arrested that have gone to a number of DMV offices here in New Hampshire and applied for licenses, and they were all using either fraudulent documents or altered documents. And 90% of them had prior drug convictions in the state of Massachusetts. Some of them had drug convictions here in New Hampshire as well. Without the cooperation of law enforcement, those individuals never would have been caught. I've encountered individuals within the state prison system. One of them, I was instrumental in making sure.
If we get back to the bill, because the bill doesn't talk about state prisons anywhere. So.
But if we don't have cooperation, then these individuals get released into the community. And sanctuary policies make it so that we don't get that cooperation. And without the cooperation, again, these people are being released back into the communities. As far as trust with aliens and law enforcement, ICE does not arrest somebody who is reporting a crime. We actually have special visas for them, U visas and T visas. So if they are a victim of a crime or a witness of a crime and they are actively cooperating with law enforcement, they're eligible for those visas. Those visas are good for about 2 years, and in that 2-year period, they can apply to become permanent residents. So they, in effect, adjust their status and are here legally after that. I've had situations where we actually had 3 individuals that we encountered.
I mean, try to, get on, because, some of this is, just more history. We believed you the first time when
Okay.
you gave us the stuff. Is it your testimony that when a detainer is issued, that a warrant is also issued, a federal
Correct.
warrant at the same time?
Yes.
And that federal warrant gives the local people the ability to arrest under that local,
No.
no.
No, a local law enforcement officer cannot arrest somebody on an ICE warrant. It has to be an ICE officer. Typically, when we lodge a detainer against an agency, if an agency calls us to let us know that they're releasing that person, we immediately go there and pick that person up, and we make the arrest based on the warrant. We do ask them to detain them for up to 48 hours, but I can guarantee you the Manchester Immigration Office is not waiting 48 hours to pick somebody up on a detainer. They're doing it immediately.
Questions from Senator Ravis?
Thank you, Mr. Chairman. In referencing just New Hampshire only, can you cite or reference any communities that have these, quote, sanctuary policies that are in place?
I know of quite a few that have unofficial sanctuary policies in place, one of which is Manchester PD. Pretty much Stratford County, or most departments within Stratford County, especially Dover. Cheshire County, they don't cooperate with ICE. Nashua Police Department used to call ICE, but they stopped. Exeter PD changed their policies and stopped contacting ICE because of a lawsuit. New Hampshire State Police changed their policies, and they've stopped contacting immigration as well. Before I retired, we were not getting any calls on the 24-hour duty cell phone. So we had that cell phone. Whoever was on call, your job was to respond to any calls from any local agencies. The calls stopped coming because everybody's afraid of being sued.
Additional questions? Okay, thank you very much.
Thank you, sir.
Bob Dunn.
Good morning, Mr. Chair, members of the committee. I'm Bob Dunn, the Director of Public Policy for the Roman Catholic Diocese of Manchester. And on behalf of Bishop Peter Labashi, I'm here today to respectfully oppose SB 132. I won't repeat things because I think Gilles and Eva have done a great job of identifying the major issues with this. I just want to make a couple of brief comments. First of all, as we all know, regardless of where we are on this issue, we know that there's a lot of rhetoric out there that surrounds it. And it's really important for us to remember that whatever we call folks, we want to call them undocumented, we want to call them aliens, whatever it is, they're people. And so we need to be mindful of the human dignity of all of the people that are involved here and not to paint everybody as a criminal. I think it's notable. I was the assistant commissioner of the Department of Safety back in the early 1990s. And one thing I learned then, and I have seen in the succeeding decades, is that the Department of Safety and the state police and the chiefs of police are not shy about coming to the legislature to make suggestions about ways to improve the public safety. And this legislation did not come from New Hampshire law enforcement. And I think that the question Senator Abbas asked earlier about discretion is really important because this legislation, especially if one looks at the way policy and sanctuary policy is defined, removes all discretion from police departments. And, on this difficult issue, the local law enforcement authorities have tried to clearly figure out how to strike the proper balance and to try to make sure that, above all, people are able to report crimes. And it's really, I think, I would suggest that the local law enforcement authorities are the ones who know the best about what is the best way to protect the public safety in the local communities. And so I guess I would ask the committee to consider, in thinking about this bill, difficult issue. We all agree that the U.S. immigration system is highly flawed. But does this bill make New Hampshire safer or less safe? And that's a question that I think I would very much defer to local law enforcement to answer. And I gather that by their absence here today and by Gilles' reference to a chief that submitted a letter, that they perceive that this bill would be unwise on that front. Thank you.
Questions from the committee members? Seeing none, thank you. If you'd check the list, I would appreciate it. Is there anyone who hasn't spoken that wants to speak? With that, we'll close the public hearing and we'll open the next one just as soon as we're ready.
Senator, would I speak with you for a second?
We're going to open the other public hearing in just a minute, so you'll have to wait till after this hearing's over.
Okay, are we still having the exec for that bill that we had talked about?
I don't know that we're going to exec it today, but we'll see.
Okay, so it ends at 12 noon, is that correct?
What, this hearing?
Yeah.
Since there's only 2 people on there, it may even end before that. So.
Okay, thank you.
All right. So, Senator Avard will open the public hearing on Senate Bill 155 and ask the prime sponsor to introduce himself.
Thank you, Mr. Chair. And for the record, I'm Senator Kevin Avard, representing District 12. I am the prime sponsor on 155 FN local. And the analysis basically is this bill revives the procedure for the adoption of the annual budget for school administrative units and repeals alternative budget adoption procedures. The basic purpose of this bill, SB 155, is to require all school districts to have a separate warrant article for the SAU budget. For multi-district SAUs, the separate warrant article will be for their portion of the SAU budget. This provides for more visibility and for voter deliberation on SAU budgets. Important since there is apparently a disproportionate growth in spending on public school administrations in New Hampshire and nationwide. Mr. Chair and Committee, I basically brought this forward on behalf of a constituent and who is here to provide extensive detail on this bill. And with that, I will close my testimony.
Questions from committee members? Thank you. Eric, I think he was referring to you.
Thank you. Thank you.
Mr. Christina, we'll have you as a cleanup.
Thank you, Chairman Gray and Vice Chairman Murphy. For the record, my name is Eric Power. I'm from the town of Brookline, and I'm here on behalf of the School District Governance Association of New Hampshire. I'm the president of that organization. It's an organization that seeks to get responsible governance and responsible budgeting in school districts across New Hampshire. Senator Vard gave you a little foreshadowing. Spending on public education is increasing in New Hampshire. And it's school administrators that are driving a lot of that. Hillsdale College president talks about the number of school district administrators growing by 79% over the past 20 years, while public school teachers only grew about 9%. So we're getting more administrators and not as many teachers. State Board of Education member Ryan Terrell had a union leader editorial where he talked about the cost per pupil is up 77% in New Hampshire, but teacher salaries are up 1%, both of those adjusted for inflation. But the number of non-teaching staff is up 80%, while teachers are up 23%. So we're hiring more and more administrators, and they're typically the highest paid personnel, mostly with six-figure incomes. In New Hampshire, many of the school administrators are employed by what they call the school administrative unit. And this year, we actually have 10 superintendents in the state, according to the Department of Education, that make over $170,000 a year, with one making over $192,000. There's 51 assistant superintendents. We have 8 SAUs that have 2 more assistants. This growth in personnel and the budget that it drives is a significant challenge. So getting to the mechanics of the bill, at most annual school district meetings, the SAU budget is part of the school operating budget. Unfortunately, that leads to low visibility and accountability. Voters have to really find the SAU budget. They have to dig it up if they can. It's not modifiable by voters. The SAU budget is approved by this SAU governing board in each December, and it's just passed along as part of the operating budget. There is a provision which Senator Vard mentioned. There's a adjusted budget provision which is part of the alternative budget procedure. So in a multi-district SAU, they do apportion it by a 50-50 formula, 50% equalized valuation, 50% average daily membership to the member districts. But even there, it becomes part of the operating budget unless unless an SAU district has actually adopted the what they call the alternative budget procedure, which is RSA 194C 9B. Currently, that law is available only to multi-district SAUs. It's not widely adopted, and it's not easily adopted because you have to get a warrant article in every district in the SAU. Most times by petition, it has to pass in a vote by a simple majority. It can be unadopted by a simple majority vote. So that's happened several times in New Hampshire. In this budget procedure, it uses a warrant article with a proposed budget, which is the budget proposed by the governing board, and then what they call an adjusted budget. The adjusted budget is kind of like a default budget under SB 2. It takes out one-time expenses, things that are not expected to continue. So the approval is done by a ballot vote at all the school district meetings, and that the collection of all the yeses and nos are collected together to determine which passes, the proposed budget or the adjusted budget. This procedure, unfortunately, isn't available to single district SAUs. It's only for multi-district SAUs because the SAU budget is just part of the operating budget. So the solution proposed by SB 155 is that the SAU budget be a separate warrant article on the annual warrant for all school districts in New Hampshire. So essentially, it's requiring the budget procedure to be used for all school districts that's available just to multi-districts today. The SAU budget already exists. People know what it is, so there's not a lot of extra work. The only extra work that might be there is to calculate an adjusted budget, which isn't that much work. This provides the voters in single district SAUs and multiple district SAUs the ability to adopt the proposed budget or the adjusted budget. But more, it provides increased voter visibility and scrutiny on the SAU budget. People know what's being spent on administrators. Voters have more of a direct say in that. They have a choice, and it makes it possible for all school districts to use it and will use it. And it's not a burden on any school district to do this. So I recommend ought to pass on SB 155, and thank you for listening to my testimony.
Questions from the committee members? Seeing none, thank you very much. Barrett?
Thank you, Chairman Gray, members of the committee. My name is Barrett Christina. I'm the Executive Director of the New Hampshire School Boards Association. We're opposed to the bill. There are a couple sort of logistical items with the bill that are problematic and don't fit with other statutes, and then there's some of the broader policy concerns as well, too. I will try and be as brief as possible. The reason that the SAU budgeting process contained within current statute in RSA 194C9 and the proposed bill doesn't exist for single district SAUs is because single district SAUs are, while they have an SAU number, they're considered single school districts. So there's no separate SAU budget for a single district SAU. I'm also reading RSA 194:1-A. Single district school administrative units. As provided in RSA 194C3, single district school administrative units shall be considered the same as a single school district. So there's problems with that language trying to incorporate this within a single school district SAU budget. There's also a provision in RSA 194C3, which I quoted, which says, I'll get to it, single district school administrative units shall be considered the same as a single school district and shall be exempt from meeting the requirements of this chapter, except that they shall provide superintendent services pursuant to RSA 194C4. So RSA 194C3 is saying that single town school districts, Rochester, Bedford, Salem, Portsmouth, the cities are different, I understand that, are exempt from the budget provisions in RSA 194C9. So the other aspect to page 1, line 13, subparagraph 2A, the provisions of this paragraph apply to school administrative units comprising 2 or more districts. And then it lists out, that's A and then B. But then we jump to page 2, line 8, subparagraph 4A, the provisions of this paragraph, meaning paragraph 4, apply to districts with an annual meeting. So again, we get back to the issue that there's a conflict of law between what the bill says and the existing language in RSA 194 and RSA 194C3 relative to single district SAUs. The other aspect, and Mr. Power mentioned it, is that this is essentially creating a default budget process for your SAU budget. We already have a provision in RSA 194C9A and RSA 194C9B that allows for something similar where the SAU budget in a multi-town SAU, a multi-town school administrative unit that comprises 2 or more districts under the single sort of operational management system within an SAU, the superintendent services, that towns can already do this. Towns can already, bless you, towns can already adopt a provision where the SAU budget goes on each town's warrant article, and I forget I think you need a 60% vote or something along those lines. I don't have the language in front of me, and my computer is upstairs in House Education, so I'm trying to read this on my phone. And Mr. Powers said that it's a challenge, to get those provisions adopted. Well, maybe it should be a challenge. If the towns want to do it, they can do it. There's already a provision in law. Nobody's stopping them from adopting the alternative budget method in 194C, C9A, and C9B. So that concludes my testimony. I'm happy to take any questions. I thank you for your indulgence.
Questions from committee members? Senator Perkins Coker.
Simple one. Do you happen to have anything written you could submit to us?
Thank you for the question, Senator. No, I do not. I usually scribble my own notes.
Thank you very much.
Thank you.
Questions? I'm used to, at least in the city of Rochester, being able to, based on the account number, pull out all of the various components from a budget. So I'm wondering why I need to do that, because in other provisions of the statute, I have to have line item budgets available for people.
Right. Thank you for the question, Senator. Yeah, indeed, you can certainly go to your line item budget and contact your business manager and say, I want to see the salaries, the conglomerate of everybody that's in the quote-unquote administrative office. The other aspect, though, too, which, Mr. Power mentioned, but I think requires some clarity. Your SAU office, your central office, does not include all your administrators. We have many district-level administrators, principals, assistant principals. Some buildings have special ed directors within the building, not district-wide. Those are not going to be calculated within your SAU budget. They're going to be within the district's operating budget. So, but yeah, you can certainly, and we have the provision that you have to have the line items in detail now for your budgets and whatnot. Yeah, I mean, if a school board member wants that, or if a member of the public says, I want to see the salaries of everybody in your central office, the business manager or the superintendent can pull that information. I don't think the issue is pulling the information per se. I think the issue is that, one, there's already another method in law, which nobody else is here to say that it's not working, and two, the conflicts with the other provisions where it contradicts with the provision in RSA 194 and it contradicts with the provision in RSA 194C3.
Additional questions from committee members? Seeing none? Thank you very much.
Thank you very much, Mr. Senator.
Assuming that the three people that are here have already spoken and there's nobody else, so we will go to the formality of letting you walk across the room and looking at the sheet. With that, we'll close the public hearing. I'd like to go into the exec session, at least to have a conversation about the various bills that are out there. We have a motion, a second, to go into executive session. All those in favor say aye. Aye. Okay, we are in exec session. Well, that depends on what the senators want to do with the bills that are on there. So, going from the bills that we have on the list, Senate bill, starting at the bottom, Senate Bill 220, an act modifying the absentee voter registration process. I know that Senator Susie has an amendment that she would like the committee to hear, so I intend to hold off on that relative to changing the date of the state primary election. Again, there are discussions going on behind the scenes on that one, so that probably won't be heard until March because of the inavailability of one of the senators to get a meeting with a certain individual. Senate Bill 92, the act relative to the authority of registers of probate, is one that we probably should discuss. And then 73, the act relative to the Help America Vote grants. If you pull out Senate Bill 92, I did receive communications, and we have one of the registers of probate here with us. They were concerned about some of the provisions. And in fairness, if you have that input from the other register, we can let you come up and at least speak to those. Well, the amendment is what I got from, but based on sending the amendment out to certain individuals, did you want to come up and talk?
Excuse me one moment, Mr. Chairman. I'll be right back.
Yep. Make sure the red light's on.
It's on now. Okay. First, I have to plead ignorance on this because I haven't really seen all of the things that may have been written as a response to this. I do know that there's been a question raised about whether registers, some of the registers would be willing to do the job that's called for in Senate Bill 92 of not being paid. So that's still a topic of discussion, I guess. Personally, I can say that I don't have an issue with that because it's more a matter of trying to make sure that those people who don't have large estates, who may not be very wealthy at all and can't afford attorneys, if the registers are there to just provide some assistance in such a way to many of the people who have no idea how to handle an estate, even how to use a computer, because that's in the courthouses, they do have a kiosk there. And so then the question is, which of the registers are willing to go forward and continue, and if 92 ends up not doing anything about being paid for time and effort to a degree, to a smaller degree, then there would be some areas, some counties that would have registers and others that might not. But that's one issue that came up. The other issue that came up, Rod Ward, who is one of the registers, has also pointed out that he determined that the kiosks in the courthouses, at least in the courthouse that he went to, was not secured. He went, number one, he went in, he was able to sit down at the kiosk, and his background is IT for many years. I just got off the phone with him, and he explained that he would have been able to actually get access into people's records, even though he did not do that. He did not go into people's records, and he made that clear.
Beyond the scope of this bill, so.
Okay. And that's about it. Let me just say one other thing. As far as the training, this is something that your bill has called for, that the registers would be trained, and I'm in favor of that, and I think all of the others are as well, because that's the role of the register as it used to be, and we're trying to make that continue on going forward here if we can.
Okay, thank you very much.
Thank you, Senator.
The thing that I had received was from Dean Dexter, who had communicated with one of the other registers, probate, and their comments was that problematic, and that the election of the registers on training, asked what other positions. Well, you can't be an attorney, county attorney, unless you have the adequate training. You can't be, there's other positions out there. Comply with belief that training should be provided. Yeah, it's going to be provided. Requiring the training verification in order to be sworn in. Again, I'm trying to make sure that, just as if you go to the county attorney, that you're talking to somebody that has the qualifications, and that should happen before. Pay. Right now, this is based on the courts already providing a navigator type program, which is an unpaid program, so I just kind of got that. Would likely have, she was talking about why she couldn't be here. Again, we're very close, okay? This has gone the gamut of trying to restore it back to where it was pre-2012 when it was changed, or 2010, 2012 when it was changed in the budget, to the amendment that we had last time for the constitutional amendment, doing away with it. This gets back to recognizing that there are people out there, if they're going to try to do this pro se, could use a little help, and if it's the same person every time, that it can cut down on and according to my calculations from what was presented the last time this similar bill was introduced, it's 7 calls per probate case that they get on their hotline. So again, I will move the bill and move amendment to 2023-0270S. Do I have any seconds?
Chairman, it seemed to me like your amendment addresses the concerns we heard raised by the Judicial Department, and I appreciate the intent, so I'm fine supporting it.
So we have a motion and a second. We have further discussion.
Question, we're on amendment 0270S?
0270S, yes.
Thank you.
Okay, seeing no further discussion, all those in favor say aye. Aye.
Aye.
Any opposed? 5-0. The bill as amended ought to pass as amended. Discussion? Seeing none, all those in favor say aye.
Aye.
Opposed?
Move
Do I have a
consent.
motion for consent? I have a motion and a second for consent. All those in favor say aye.
Aye.
All opposed? And so that will go on next, the calendar, and we should be able to act on it on Thursday. Is there anybody that wants to take it out? It's my bill. I certainly will take it out.
You should.
Okay. It'll be me. Okay. All right. So I didn't act on any of those, and I don't know that you're ready to do anything on any of the bills that we heard today. If anyone wants to discuss any of those others, we certainly can do that at this time.
Chairman, I'd just like to share, I do have an amendment prepared for 73. I didn't get to circulate it to you guys before today, so I don't know that we're ready to act on it, but it's intended to serve as a starting place to address some of the concerns raised by my colleagues, and I would love to work together with you on it if any concerns still remain.
All right. I see $5 million on that. That's the start of my concerns, I guess. So, all right. Anything else anybody wants to talk about in the executive session? Okay, see.
Are there any other bills that we can exec today?
The list here was, we've already done 92, so it'd be 73, which we just got the amendment on, 133 and 220, which Senator Susie has an amendment coming on that. And then because of most of the bills that we heard today were complex in nature, I would rather you take a breather and think about them before we do anything on them.
If I can just, as a precursor, with Senate Bill 132,
Yep.
that would involve the sanctuary cities policy.
Yep.
There was a much shorter version of that passed in the House last term. It was HB 1266. I just perhaps take a look at that for our discussions, and that particular policy.
Tricia, if you would get a copy of that and send it around to everyone, I would appreciate that.
We can discuss it more after everyone gets a chance to review it.
Yep. Any other things to be talked about in executive session? Seeing none, I'll take a motion to come out of executive session.
So moved.
We have a motion and second to come out of executive session. All those in favor say aye. Aye. And our business of the day being completed, we are adjourned.